Basically, I want to focus on four aspects. There are more, but four aspects of what the Supreme Court justices said regarding the UGC rules or regulations, which is generating very serious discontent. I cannot, of course, tell you what precisely was in the mind of these two, the Chief Justice and the other Justice of the Supreme Court, and that's something that none of us can know. But I do believe that the message they gave is extremely important. It's more than one message, several messages they have sent, extremely important for Indian polity, Indian society, Indian culture, and Indian people. And it's a warning, and on the one hand, to us, at the other, it is pointing out to a lot of problems. And I think it would be intelligent to listen to them very carefully. So, the first thing I found very significant is the fact that the Supreme Court justices asked that 2 or 3 experienced jurists are involved in drafting. Not so much the legislation in drafting these rules. Now, what is the message? What exactly were they saying? Now, in one of the conversations I had, somebody made a remark that they intended that some kind of procedural refinement takes place, and that to address it, we need specialized people. I think it's completely wrong. The justices were not talking about it, and worse, they could not have been talking about it because of the following reason. They were talking about experienced jurists. Now, jurists are those who think about law, about court judgments, and where necessary, whether they are followed or not, suggest problems and solutions to that. Jurists are normally differentiated from lawyers. Lawyers argue a case in the court. Jurists could also do that. But basically, jurist thinks about these arguments, sees what the judge decided, relationship to laws, and so on and so forth. In other words, jurists deal with one of the fundamental sources of law, or 2 fundamental sources. One is what the lawgiver says. Second is how the judge decides, or what the judge decides, who is supposed to follow the law. Now, what it asked is, the Supreme Court justices, what did they ask? That experienced jurists are involved in the process, which means that these regulations exhibit a fatal flaw, or fatal flaws even, because it affects the system of law and justice. Now, what exactly could they have? What is the message about then? Let's look at it a bit more generally. You see, we have something called the criminal code. And we have statutes like, or legislations like, Atrocity Act, And now, with respect to scheduled castes and scheduled tribes, and then there are other backward classes act, and now this. Apart from that, we have statutes about defamation, hate speech, disturbing peace, and so on. So if you look at these, and that is legislations about disturbing peace, hate speech, and so on, compared to, let's say, something like Atrocity Act, then you find if you look at it, you see that more or less in the Atrocity Act and also here, people have mostly copy-pasted laws from, let's say, disturbance of peace, libel and defamation, disturbing peace, hate speech. They copied and pasted it to, say, Atrocity Act and this one. Now what's the problem with that? Isn't it a good thing? You might feel like saying that's existing laws, they function well. So they made a new law, copy-pasting the same thing. Now, actually, this is one of the biggest problems we are facing. What are the problems? To begin with, here is a problem at some level, tackled at the level of justice, tackled at the level of court itself. Now, you have on the one hand the general law about defamation, libel, disturbing peace, hate speech, and then you have this legislation, which is a particular law because it's directed against some people and defending one group or another, scheduled castes, scheduled tribes, backward classes, and so on, or other backward classes, and so on. The problem is, how does one interpret, let's say, insult based on caste from general insult as such, as it is defined in libel and defamation acts? Now, the justice, those who, let's say, give even a slightly different interpretation with respect to Atrocity Act, would be deviating from the general meaning given within the Indian Penal Code. Which means what? You begin to create parallel justice systems, each, in a manner of speaking, developing its own jurisprudence, developing its own understanding about what hate speech is, what insult is, what libel is, what defamation is. And this generates multiple problems. One, when you have these systems, which system should be followed? Should insult to scheduled caste be treated completely differently from defamation or not? So this multiplies because this copy-pasting. Second problem, when they are in conflict with each other, what prevails? Assume there is a conflict between how defamation is understood in the Penal Code and how it is understood in the Atrocity Act, which gets precedent. Does one, if there is precedence, does one overrule the other? If one overrules the other, why not eliminate that which is overruled and retain only that which overrules? It has impact on the justice system itself. What kind of punishment? Should someone be punished more severely because scheduled caste is defamed, or the leadership of scheduled caste is defamed, or should the defamation be the same to both, Except in this case, it's about the scheduled caste. In another case, it's about, I don't know, a politician, a bureaucrat, a respected figure, whoever. So, punishment begins to differentiate. Interpretation begins to differentiate. Not only just differentiation, they will begin to, as it's happening in India, come into conflict with each other. Now, the legislator does not notice even this conflict, doesn't even clarify what should be done. It is left to whom? The police, the bureaucrat, the judge to decide. Now, this violates the very idea of law-governed system, because it is unclear what is being criticized and what punishment should be given and what rules should be applied. There's another kind of a problem with respect to one who is, let's say, taken to court. He doesn't or she doesn't know which of the laws about libel or about atrocity, insult is going to apply to the person in question. Prosecutors don't know that. So prosecutors start shopping. I'll take this, I'll take that. So it's purely a question of maybe how he's going to win. And then, of course, you have the judge. And the lawgiver, who must give you clear instructions, does not give it. Transfers his responsibility to these people. More importantly, something else happens. Imagine, let me give you an example. Imagine somebody steals or somebody murders. So the question is, what does the criminal law do? Well, criminal law punishes the behavior. This is the act of stealing, the law defines it. This is murder or homicide and so on. Law defines it. And no matter who it is, this conduct is judged. But insult, which is normally also a conduct, hate speech, which requires conduct verbally, this applies differentially. That is, somebody who insults, let's say, Shankaracharya, it's not a problem, it's not an insult at all. Somebody insults Ambedkar, Phule, whichever respected figure from the scheduled castes or scheduled tribes, punished for the same act. So, when you differentiate conducts, then your law is not about the conduct anymore. It depends upon the identity. So, if I murder, it's okay. If he murders, it's not okay. What does law do actually? Law should just decide about the conduct. So, this way of approaching undercuts precisely what is the most characteristic feature of law, namely, describe a conduct, define punishment, and say under which rules the conduct falls. Precisely, that's completely undercut. So, you have a situation where you have, let me summarize, multiple laws, multiple statutes, conflicting with each other, which do not follow each other, necessitating multiple interpretations, multiple punishments. So, to talk about Indians are under the rule of law is a mockery, because that's not what is happening. That's not how things are working. Take a bigger example. Well, expand it a bit more. One can understand the motivation, which is a political motivation, which is a moral motivation. Namely, for example, how did they defend atrocity acts? They said, yeah, the law is not being applied properly. Therefore what? They said, we need a special law. Now here is the problem. If the laws were not being applied properly, it's because the police didn't do what they had to do, the bureaucrats didn't do what they had to do, justice system didn't do what they had to do. If that is true, and you change and set of legislations, It is still the same old police, it's still the same old bureaucrat, it's still the same old justice. And the problem was they were not doing it. So now all they will do is add, according to this law, and add Indian Penal Code and Atrocity Act. So by simply making new legislations of whatever kind, you are not addressing the problem. The motive which gave us to that is undercut, because everything the others were doing, they'll continue to do so. So it is creation of absolute chaos is the result. Instead of what, you may ask? You see, in one of the talks, in a discussion, somebody said, this is all a question of procedural law, and that is not important. The funny thing is this: if only they were to amend existing laws, for example, change the conditions of bail, maybe even create special courts, maybe give witness protections and so on, these would be amendments to the existing law. That is, this is a procedural question. Put differently, this is the question of bureaucratic housekeeping. Some law is not working properly, then the legislator should say, this aspect is not working properly, we are going to add it. This should be an amendment, this is procedural. Substantive law, which is what you should be, is introduction of new laws, new legislations. That is substantive law. Now, if you introduce that, all the problems you've seen will re-emerge in more acute form and in an unsolvable way. And that's exactly what's happening here. So, there is no support or clarity or certainty to those who are charged. There is no clarity about how they should be charged. There is no clarity about what should be used to judge the conduct. There is no clarity about what kind of punishment should be given. And when you copy-paste, contradictions emerge, as they are emerging. Today, if anybody who looks at these kind of laws, will see these inconsistencies and contradictions. So instead of having a coherent, systematic law which applies to all the people, we have an incoherent jumble of fragmented laws which, so to speak, appeal to the Indian Constitution. So to speak, because it's unclear when the conflict comes between statutes, how one judges it. So now we begin to understand why the Supreme Court justices wanted experienced jurists to look into this issue or to use them to build these rules, because what I have spoken about are all what one could call issues of law, issues which are jurisprudential in nature. Therefore, we need jurists. Having said that, I must confess to a puzzle. Why hasn't the Supreme Court made similar remarks with respect to the multiple legislations that have passed through? Like, for instance, why did they not point out the problems that something like Atrocity Act, the two of the acts, have created to jurisprudence, to law, to the system of law in India? But I'm very glad, whatever the reason, I'm very glad they have done so now, because it is not only urgent, but if we don't do it, if we don't attend to it, it is an absolute disaster and catastrophic in nature. However, you might have two questions, well, more than two. You'll have some questions. One is, well, how did this process of these fragmenting the legal system, how did it come into existence? Why does it reproduce itself? Why do people keep doing it all the time in India, whether it's regional governments or federal government or central government? Now, of course, I can't at the moment give you to either of the two issues any deep answers. That requires more understanding of the situation, but I can point out to 2-3 elements which are very crucial for us to understand. One is, of course, the British, the colonial justice system. See, to the British, there are two aspects which are important. One is its self-image, namely the civilizing mission that the British had, or thought they had, it doesn't matter how you look at it. A second is what they were doing in India. Now, if you only focus on their image, I think it's extraordinarily important, because that civilizing mission made them want to bring in a coherent system of law into India, so that they could perhaps feel satisfied that they brought in the legal system into India. And they tried. Now, but of course, the exigencies of ruling, namely they had to deal with all kinds of intermediaries, they had to deal with the princes and Mughals and so on, and different groups, and also the fact that in India there were multiple kinds of sort of rules, one for the Muslims, one for the Hindus, one for other groups and tribes, even amongst the Hindus, about inheritance and so on and so forth, which is what they discovered, if you like the word, extraordinary pluralism in India. So it was not an evident task to create one coherent structure of law, one general system of law. So how did they reason? They came up with emergency measures of sorts, local problems are resolved or addressed by creating local laws, but they always had the idea that these were temporary measures, and that sooner rather than later, it would be absorbed into a general law, a systematic law. But in the process, what did they do? In the process of governance, that is, we started a kind of an accretion of law, that is, one law on top of the other. Now, what happened after the independence is we just started adding one after the other. We simply got an accretion of laws without either the motive or the goal or the ability, perhaps, I don't know, to bring them together into a coherent law. And these fragmented legal systems we are creating after independence continue, on the one hand, what the British did, and on the other hand, and this is the other aspect, or also Indians, how Indians judge, how Indians work. Like if you know that we had Dharmashastras, Dharmasutras, Arthashastra, Mahabharata, etc., that speak about actions, conducts, rules, etc. Now, even grammar rules, if you like. Now, one of the problems is, which Indians did tackle, what happens when there's a conflict? For instance, Arthashastra says something else, Dharma Sutra says something else, one Dharma Shastra says something else. So, in cases of conflict, what do we do? So, there were all kinds of temporary ad hoc measures used, namely take one which is later, take one which is earlier, take one which is take the recommendations because of the tradition, and so on and so forth. In other words, this mode of deciding issues and accretion of laws, that is something very characteristic of Indian, legal, moral, ethical, and even linguistic traditions. So these two combined create a tendency, if you like, which emphasizes, reproduces accretions. And with accretions, which are the kind of framework required for law, general law, systematic law, you have conflicts and the kind of problems I just indicated. Now, having a constitution will not solve these problems. It has not solved them. Reasons are many, but by simply appealing to the constitution as the framework, these problems do not get solved, because maximally the constitution can create a foundation, but a constitution does not replace, cannot replace a general, coherent, systematic law which brings together the civil, the criminal, and so on and so forth together and creates a clear, identifiable sets of acts, punishments, and instructions about how to judge it. So, yes, it is to some extent historical, yes, it is to some extent cultural, but it does puzzle me enormously. I have always had this problem in the last 4 decades. Why is it India has not generated jurisprudence of that type we so badly need? When people take decisions, whether it's about fundamental rights or about religion, they simply go, take some judgment from some country or another, put it together, and just make judgments. Now, this is not jurisprudence at all. And if you look at the text, in fact, the only place where I can find some serious work on jurisprudence, there are exceptions, like Mr. Upendra Bakshi, for example, like some of the top Supreme Court advocates, for example, but these are outliers. If you want to find out what is Indian jurisprudence, basically you have to go to law textbooks, and even in that law textbook you'll get 1 paragraph, 2 paragraphs about jurisprudence, and the references are mostly, depending upon the kind of laws we are talking about, are references to what the British judges said and did not say. So, in other words, what we must understand is that the UGC rules are expressions of a very deep lacuna in Indian thinking, not just about law, about the problems they're facing. What kind of problems are they? Are they social problems? Are they political problems? Are they legal problems? Are they ethical problems? You see, depending upon the nature of the problem, you have to give the solution. I mean, if you don't know what the problem is, it's like giving any medication to any sickness. And you know the results. Absolute disaster. And that is what's happening in India. There are multiple other questions which I'll take up in the course of the next few fragments, but I'll be focusing on what the Supreme Court said, which I find extraordinarily important. I'm very glad they said it. A point is, I am not a specialist in law, I am not a jurist, but what surprises me is why are the lawyers in India, the top Supreme Court lawyers in India, why is the Supreme Court an other courts in India have been silent on an issue which is destroying the foundations and structure of law in India. So what I am telling you, what I am sharing with you, is my understanding, not so vague, but I am not a specialist, I am not a jurist, I am not a lawyer. But when people who should be responsible, namely the judges and the lawyers and the jurists, do not say anything, I'm afraid it's left to somebody like me, a lay person, to draw your attention to the problem. Namely, the problem is huge, it's gigantic. And these kind of regulations UGC has made will not take us even one step further. But I'll come to that when I take up other issues. It's simply going to destroy further, if it is required, what has been destroyed in the last 80 to 90 years, namely the Indian education system. And not just the Indian education system, it's going to destroy society, not UGC rules on its own, of course not, but destroy society, destroy culture, and destroy the education system. But in what way could these things be stopped? In why are they occurring? To some extent, we can think about it, and that's what I want to do in the coming fragments. Thank you.